I am very appreciative of the potential cost savings, the potential increased training by bringing into the Secretary of State's office the handling of initiative petitions, the verification process for these initiative petitions. My concern is that there is currently no remedy for valid electors whose signatures are wrongly tossed out during the signature verification process. And, you know, I'm mindful of the fact that when I prepared that amendment, I was approached by two lobbyists for organizations that I strongly support and have for the entire time that I've been involved in politics in this state. And they were very disappointed that I'd offered the amendment, and they suggested that it would be a problem for them to work with me moving forward. And it was the kind of pressure that I didn't particularly appreciate. That's the kind of pressure that I think the Secretary of State's office needs to be insulated against. My concern is that unless we provide a remedy to valid electors whose names are wrongly excluded, it can open up the Secretary of State's office to charges of corruption or the appearance of corruption or the appearance of undue influence in a way that really isn't fair to the professional staff of that office.
I'm troubled with that the same provision that Sal mentioned was dropped from the -1 amendments, and that is simply allowing petitioners to correct things on the sheet that are clearly wrong. For example, some folks, like we in the last cycle, went to the trouble of entering all of the signatures and addresses into a database so we could make sure that we weren't going to be harmed by having a number of duplicate signatures be counted. Every duplicate signature that is found counts 400 against you. Every triplicate signature, I can hardly imagine what that's going to count against you. I don't even remember. But the current interpretation is that if we go through our petitions and we find a duplicate signature, and they may be signing a duplicate deliberately in order to reduce the number of valid signatures that would be found through the sampling process. We find a duplicate signature, we cannot cross it out because doing so invalidates the entire sheet. The only way to avoid the duplicate signature is to throw away 9 valid voter signatures. Okay. Number 2. Let's say we find a signature that says Frank N. Stein at Transylvania Boulevard. Okay, we know that's wrong. Should we cross it out? Well, we can't now, because if we cross it out, that invalidates the entire sheet and 9, hopefully, valid voter signatures, people who don't live on Transylvania Avenue. So that's what this amendment attempts to do, is to allow the provision in House Bill 2082 to be implemented in a way that is not blatantly disrespectful of the rights of people who sign petitions. But that is the way it is proposed to be implemented now. On the -2 amendments, just briefly, I think you will be revisiting this because I've heard that the referendum 303 case will be appealed. And it's what the Ninth Circuit has said is that voting is a fundamental right subject to equal protection guarantees under the Fourth Amendment. The ballot initiative, like the election of public officials, is a basic instrument of democratic government. I'm leaving out the cites. And is therefore subject to equal protection guarantees. These guarantees further apply to ballot access restrictions just as they do to elections themselves.